whatever.
Okay, well, moving on to our next panel, I'm really delighted to introduce this panel dealing with Establishment Clause issues. I'm going to introduce them in the order in which they're going to be speaking, which does not happen to be the order in which they're sitting. But our first speaker will be Professor Douglas Laycock. He is the Armistead M. Dobie Professor of Law and Professor of Religious Studies at the University of Virginia. He is also the Alice McKean Young Regents Chair in Law Emeritus at the University of Texas at Austin, where he served for 25 years. And in between that, he was at the University of Michigan. He's published far too many articles to count on the subject of religious liberty and other issues of constitutional law. And he's also published articles and books on the law of remedies. And as a matter of fact, his many writings on religious liberty are the subject of a forthcoming 4-volume collection from Eerdmans Publishing. And the first volume, Overviews in History, is currently available. In addition to that, he's an experienced appellate litigator, including in the Supreme Court of the United States, and has worked behind the scenes on state and federal religious liberty legislation. He's represented clients across the religious and political spectrum, from the National Association of Evangelicals to the American Civil Liberties Union. Professor Laycock is going to be speaking on the Ten Commandments, the Cross in the Desert, and the Supreme Court's expedient turn to postmodernism. Our next speaker then will be Professor Mary Jean Dolan. She's an assistant professor of law at John Marshall Law School in Chicago, where she joined the faculty in 2007. She teaches constitutional law, family law, religion in the law, and lawyering skills. And her scholarship has focused on the First Amendment area, which is an area in which she gained expertise when she wrote laws and policies and advised the city of Chicago. She has recently published a law review article that expands on an amicus brief that she authored in the Supreme Court case of Pleasant Grove City v. Summum. And she has published other articles in the William and Mary Bill of Rights Journal, Catholic University Law Review, Hastings Constitutional Law Quarterly, and other publications. And then our third final speaker is Caroline Corbin. She's an associate professor at the University of Miami School of Law. She holds a BA from Harvard University and a JD from Columbia Law School. She clerked for Blaine Michael of the Fourth Circuit and worked at Sullivan and Cromwell as the pro bono fellow, as well as at the American Civil Liberties Union Reproductive Freedom Project, where we briefly overlapped not so many years ago.
Not so many. Not so many.
She's also an expert in the First Amendment, and her articles have appeared in the NYU Law Review, UCLA Law Review, and Boston University Law Review. So I will turn it over to Professor Laycock without.
Well, this panel is actually about title of this conference and not about the subtitle. This is not about government compelling or restricting anyone else's speech. This is about what government can say itself about religion. So we have this rule that says, in Justice O'Connor's formulation, but the rule is actually older than that, government cannot endorse a position pro or con about religion. Government cannot take a position on questions of religious truth. In the Founders' time, they said government is not a competent judge of religious truth. But in many parts of the country, there's substantial political demand for government to violate that rule. And so government lawyers, who have to defend what their clients have done, interpret religious text and symbols to have secular meanings. And they say, well, yeah, that's a depiction of a miracle, but we had nothing to do with religion. This is only about retail sales at Christmas. There's much sham litigation of that sort, and I want to talk about a couple of those cases. Starting with the Ten Commandments, there were two cases in 2005 that came up from different parts of the country to be decided together. I'll talk about Van Orden versus Perry, which was the Ten Commandments monument on the grounds of the Texas State Capitol. It was one of many Ten Commandments monuments around the country donated by the Fraternal Order of Eagles in the 50s and 60s. It This is a project that started out small and got very large because at about the same time Cecil B. DeMille was making a movie with Charlton Heston and Yul Brynner about the Ten Commandments. He thought it would be great publicity to have these monuments, so we have Brynner and Heston showed up at some of the dedications, 6-foot-tall red granite monoliths with a condensed text of the Ten Commandments engraved on it. They're pretty much identical around the country, minor variations. The Texas one at the top in large letters, bigger than the rest, says, "The Ten Commandments, I am the Lord thy God," and then the text of the commandments in smaller print that follows. And you know, no one, all the politicians revere the Ten Commandments, none of them know what any of them say, so let me remind you of a couple. Thou shalt have no other gods before me, all right? Remember the Sabbath to keep it holy, that thy days may be long in the land that the Lord thy God hath given thee. Some explicitly religious provisions and some that have secular equivalents. Thou shalt not kill, thou shalt not steal, thou shalt not bear false witness, but presented here as direct commands from the Lord thy God. Well, so that's obviously not religious. It's about the history of Texas. There are 17 monuments on the Texas Capitol grounds, donated by different people over the years, and they're all about the history of Texas. What sort of a Sesame Street questions? You look at the list, which of these things is not like the others? 15 of the 17 are monuments to people, many of them to military units, many of them to Confederate military units. There's a monument to volunteer firemen who've died in the line of duty. There's a monument to the pioneer women. There's a monument to the children of Texas, Korean War vets, World War II vets. There's a replica of the Statue of Liberty, small scale. That's the only one that's to an idea rather than a person, although there's a person in it. The only one that's religious is the Ten Commandments. The only one that is simply a text is the Ten Commandments. The Supreme Court upholds that monument, strikes down a somewhat different Ten Commandments display from Kentucky for reasons that I'm actually going to skip over. There's no majority opinion in Van Norden. I think what is much more interesting is what comes next in a case that Mary Jean is going to talk about, Summum versus a little town in Utah. Same monument, donated by the Eagles, same text of the Ten Commandments, but a different claim. Summum is a religious group in Utah that claims it has the other statements that were given to Moses at Mount Sinai and that were hidden all these millennia because the people were not ready to receive them. And these are the 7 aphorisms of Summum. And their claim was the city has created a public forum because it accepted the Ten Commandments monument. Now it has to accept any other monument that any private speaker wants to donate. Well, it's an idiotic claim, right? It can't possibly be that you can fill up the park with monuments from every Tom, Dick, and Harry who wants to put one up there. They somehow won this case in the 10th Circuit and not surprisingly lost it 9-0 in the Supreme Court. The question is, how did they lose it? But note too, the very posing of the case makes explicit what had always been implicit in these religious endorsement cases. When the government endorses a religion, it plays sides, it takes favorites, it endorses one religion, it's not going to endorse any of the others. And it's certainly not going to endorse some religion that the public officials think are a bunch of crackpots who claim to have recently rediscovered a 4,000-year-old tablet from God. Maybe they did. Government has to be agnostic about that question. So it's a stupid claim, and it's not surprisingly that the court rejected it. It's not surprising that it was unanimous. I filed a lot of amicus briefs. I didn't file in Summum. I didn't think I had anything helpful to say. There was nothing to be said for what the city was doing, and there was nothing to be said for Summum's claim. So Justice Alito writes the opinion. And he says the obvious things, right? Government doesn't have to accept from Iraq a statue of tyranny to put in New York Harbor next to the Statue of Liberty. And we can't clutter up all the public spaces with whatever somebody wants to donate, and so on and so forth. But then he says, just because the city accepted the Eagles Monument with the text of the Ten Commandments doesn't mean that the city endorses the text of the Ten Commandments. They might have accepted it for reasons having nothing to do with the Ten Commandments. They might have accepted it because it's important to the history of the city, echoing a theme from Van Orden. And then he says, and this is what I mean by their turn to postmodernism, the plaintiff seems to think that a monument can convey only one message, which is presumably the message intended by its donor. I would have said the message it actually says on the front of the monument, but he says this argument fundamentally misunderstands the way monuments convey meaning. The meaning conveyed by a monument is generally not a simple one like beef, it's what's for dinner. Even when a monument features the written word, the monument may be intended to be interpreted and may be interpreted in a variety of ways. And then he talks about some examples that were in amicus briefs. What, for example, is the message of the Greco-Roman mosaic of the word imagine that was donated to New York City's Central Park in memory of John Lennon? Some observers may imagine the music that Lennon would have continued to make if he hadn't been killed. Others may, quote this one exactly, others may think of the lyrics of the Lennon song that obviously inspired the mosaic. Well, duh. If it so obviously inspired the mosaic, maybe that's what it refers to. He says, to take another example, what is the message of the large bronze statue displaying the word peace in many world languages in Fayetteville, Arkansas? Peace? Well, just maybe. Consider the statue of Pancho Villa that was given to the city of Tucson by the government of Mexico with a wry sense of irony. Does this statue commemorate a revolutionary leader who advocated for agrarian reform in the poor or a violent bandit? And he's got some other examples. It frequently is not possible to identify a single message that is conveyed by an object or structure. Well, no doubt that is true up to a point, but keep in mind that this is coming from the side of the court that believes it can interpret statutes by simply reading the text with no reference to legislative history or to context. The monuments he uses to illustrate are all monuments that do not have a single complete sentence of text. Imagine, peace, statue of a controversial human being. When you have full sentences that parse in ordinary English and have pretty straightforward meanings, maybe the answer would be different. I suggested that the way, in an amicus brief, the way out of all this sham litigation is a return to plain English, that when government displays a sacred text, it endorses that text, not quite period paragraph, but a very strong, not bursting bubble presumption that it endorses that text, unless the government visibly and objectively negates that endorsement. And I think that presumption grows out of ordinary human experience. It is rare to put up a sign that you disagree with. People who put up signs want to further disseminate the message on the sign. And if the government has some unusual intention that does not include wanting to disseminate the message on the sign or on the monument, the reasonable observer that figures so prominently in the endorsement test has no way to know that. So the government has to visibly negate the apparent endorsement. The negation has to be equally open and obvious. It has to be objectively reasonable. It has to make sense to dispel what any reasonable observer would assume, which is that the government agrees with the messages that it promulgates. And we can largely specify the kinds of evidence that exist in the real world that might rebut that presumption. Most importantly and most obviously, a sacred text may be part of an explicit secular message that is objectively neutral with respect to religion. If you put these Ten Commandments displays in a museum exhibit on the history of the Jewish people, or a comparative exhibit on world religions, or a history of great lawgivers, then you see why it's there. And it's not about the truth claim of any particular item in the exhibit. It is about this category that can be studied objectively. The Ten Commandments, Moses with the Ten Commandments on the frieze of the Supreme Court, is accompanied by some guys that we obviously don't endorse. Draco from Sparta, the guy who wanted capital punishment for every offense. Confucius, a whole series of famous lawgivers. That's rather different from the Ten Commandments standing all by itself. The claimed secular message has to make sense. In the Kentucky Ten Commandments case, there was some slapdash stuff kind of thrown together that obviously made no sense, and the court struck it down, and the dissenter said, there's no constitutional requirement that politicians make sense. Well, obviously not. That wouldn't be enforceable. But the fact that the so-called secular things they were saying didn't make any sense had strong evidentiary value on the inference that what they were really interested in was the religious message, and that the alleged secular message was a sham. One that hasn't been litigated, government units sometimes take pithy or eloquent formulations out of religious text, and they have no explicit religious meaning. They have a clear secular meaning. It's appropriate in the context. And it seems to me that is usually unobjectionable. So over the main entrance to the University of Texas Law School is inscribed that they shall truly and impartially administer justice. Perfectly appropriate for law school, comes from the Book of Common Prayer. Not many people know that. And it doesn't seem to be imposing any religion. There are some more controversial examples, but that one seems to be okay. There's always going to be a de minimis exception, and I think that's more an exception than a way of overcoming this presumption, but of course there will be a de minimis exception. Symbols may be harder to interpret than text, but some of the symbols that are often issued in these cases have clear, well-known, and ambiguous primary meanings, and it seems to me impossible to ignore them. So let me talk a little bit about Salazar versus Buono, which is the cross in the desert. Freestanding cross, no other symbols around it, not on an individual grave, not in a cemetery, just out in the middle of the National Preserve, a cross standing up on a big rock outcropping, and if you climb to the top of the rock, at times there has been a plaque that said this is the cross was erected in honor of America's war dead. District Court and Ninth Circuit said unconstitutional, no cert petition. So that's res judicata. Congress then moved to privatize the cross, which would cure the violation if they really did it, and the issue the second time around was, did they really do it? Given that the cross was designated as the White Cross World War I Memorial, there was a reverter clause in the deed that the land came back to the government if it was ever not maintained as a war memorial. The land was sold to the VFW with no one else being given a chance to bid. And there was no requirement of any fencing or signage to mark off the private land from the surrounding governmental land. We'll let that issue go. Let's talk about what the cross means, because the government couldn't relitigate the constitutionality of the cross, but they laid in through their brief suggestions that, really the cross hadn't been unconstitutional in the first place because it had a religious meaning. They didn't try to deny that, but it also had a secular meaning. It was a way of honoring war dead. And so it was not an endorsement of Christianity. And some of the justices said similar things in their opinions, all in dictum, and Justice Alito, concurring, cited his Summum opinion about how things can be interpreted in all sorts of ways. Plaintiff said, and the Jewish and Muslim war vet said, cross only honors the Christian dead. Which seems like a rather obvious point. Scalia, to our argument, says that's an outrageous argument, to which Bono's lawyer replied, Your Honor, I've been in a lot of Jewish cemeteries, and I've never seen a cross. Well, unpack that a bit. Why wouldn't he see a cross? We all know, but it helps to spell these things out. The secondary meaning that the cross has for honoring the dead is entirely derivative of the primary meaning. Right? The primary meaning, the cross is a symbol of the Christian belief that the Son of God died on a cross, rose from the dead, and those who believe in him will also rise from the dead and live forever. And rising from the dead is a pretty good deal if you're already dead or if you're expecting to be dead someday. So, yeah, a cross honors the dead because it is a symbol of the resurrection. Right? The secular meaning isn't a separate meaning. It's not an independent meaning. It's simply an application of the religious meaning. And the promise of resurrection is only to Christians. To everyone else, there's not a promise. There is a threat. So, you know, evangelicals have made famous at baseball games and in other venues, John 3:16. But listen carefully, for God so loved the world that he gave his only begotten Son, that whosoever believeth in him should not perish but have everlasting life. And the negative pregnant is made explicit 2 verses later in John 3:18. He that believeth not is condemned already, because he hath not believed in the name of the only begotten Son of God. So the Muslim war vet said, look, this isn't a promise, this isn't an honor, this is a threat. Yeah, this is a symbol of the Christian belief that we're all damned because we don't believe in Jesus. Now, if you look at the opinion polls, most American Christians don't believe that anymore. Even most evangelicals, salvation by faith alone, don't believe that anymore. But that's certainly what the Scriptures say, and that's certainly standard form Christian theology, especially Protestant theology. So to say that a government-sponsored cross does not endorse Christianity, it seems to me, is to read Summum as committing the court to a bad version of postmodernism in which no text or symbol has any core meaning. Any text can be manipulated to mean anything. Now, of course, I understand this is all a game of pretend for judicial opinions. Everybody on both sides knows what the cross really means. Everybody knows what the Ten Commandments really mean when they read them. These opinions desacralize sacred texts and symbols, but the religious side takes its win and ignores the opinion. And the clearest example of that is in the litigation over under God in the Pledge of Allegiance, in which the Justice Department filed a brief in the Supreme Court that said, when we ask children to recite that the nation is under God, we don't really mean any reference to God. All we mean is to refer to certain historic and demographic facts that most of the American people throughout most of our history have believed in God. That's all. We're taking the name of the Lord in vain. We're not actually acknowledging God. At the same time the Justice Department was filing that brief, the White House form letter that it sent out in response to anyone who wrote in about the pledge case talked about the importance of the pledge. I wish I brought it with me to quote the key sentence, but they characterized the pledge as a brief and succinct prayer. Now that's maybe a little over the top too, but it's a lot closer to the truth than the Justice Department brief. So we characterize these things in two very different ways. The government lawyers rationalize them in quite implausible ways as entirely secular when they file the brief, and that path lays open for anything the justices want to uphold, and they seem to want to uphold quite a bit these days. But the same politicians say very different things to their constituents, and no one really believes that these explicitly religious symbols and texts actually have secular meanings. The court may take away this whole body of Establishment Clause law by taking away standing, but if they don't do that, they seem well on their way to taking it away on the merits by saying we are willing to believe absolutely any nonsense you want to offer about what these clearly religious texts and symbols actually mean.
Well, that's a tough act to follow. I have to, of course, start by thanking Case Western Law Review and the two Jennifers and the Associate Dean and Professor Jesse Hill for having us here. It's been a wonderful symposium so far. I was very excited about speaking here with two of the scholars whose work I've really admired and enjoyed and read over the years. I was a little skeptical about how, no, I was a little skeptical knowing that I was going to look a lot less sympathetic than they did, since I was a government lawyer for a number of years, representing the city, trying to handle these religion and speech issues. But now that Doug has spoken, and I know what Carolyn's going to talk about next, now I know I'm really going to look like the bad person here. But here goes, because I'm going to try to give a centrist view. I want to start with an overview of the intersection between government speech and the Establishment Clause. And then I'm going to look at two issues. First, what do Summum Buono suggest about the future of the Establishment Clause? And second, what kind of disclaimers can bridge the gap created by an Establishment Clause that has become less sensitive to non-adherence? So my working theories are that the two cases leave the endorsement test intact for now, though it probably will require a name change to survive. And I read Pleasant Grove versus Summum as changing the Establishment Clause calculus. Its government speech holding rested on government's broad expressions of identity and values. Where that includes religiously themed monuments, the new minimum baseline requirement should be explanation of the secular meaning and disclaimers of the religious viewpoint. And I think Salazar versus Buono can be read as applying an expanded endorsement test, one which asks the reasonable observer to consider as an additional contextual factor the social meaning of removing a specific religious historical symbol. And then finally, as historic preservation values merge with the viewer-centered approach, we really do need these context-providing narrative disclaimers. They're very essential in those cases where they do work. So I'm taking an intentionally optimistic position, you might call it foolish even, because it seems to me that that's what's needed most right now, both to guide the lower courts with these cases that they've been given and to persuade the undecided, the centrists, to let go of the less generous approaches that threaten. And I think that the most realistic starting point for a doctrinal prediction is Justice Kennedy's pronouncement in Bono. The goal of avoiding government endorsement does not require eradication of all symbols, religious symbols, in the public realm. I think it's clear that 6 justices will resist ripping out long-standing public statues with religious themes. And so which test is used and what reasons are given are the critical questions right now, with consequences for all types of religious speech questions. So I'm going to use Justice Souter's parting thoughts from Summum as a sobering frame for examining the problem here. He said the interaction between the government speech doctrine and the Establishment Clause principles have not yet begun to be worked out, and this case shows that it's not going to be easy to do so. So he proposed using the same endorsement test to address both types of claims. Using his approach, Souter agreed that the 10 Commandments was indeed government speech, which he said meant that it was an expression of the government's position on the moral and religious issues before it. In other words, he's claiming that the court's holding means fairly clearly that through this display, the city is expressing its own religious viewpoint while rejecting another's, which has not been the case in these Establishment Clause cases. And I also do agree with Doug on the outcome of Van Orden being wrong, but I think things have changed a little bit with Summum, as I'm going to describe today. So one of the ongoing puzzles here between the two doctrines is that they work in opposite directions. So building off of Justice Souter's description, in Establishment Clause cases where government is supposed to avoid expressing a religious message, it typically increases the number of speech objects for purposes of diluting that religious message. Think of the creche surrounded by snowmen and carolers in Lynch. However, the more objects on display, he argued, the harder it then becomes to say that each one conveys a governmental message. And so by taking steps to ward off an Establishment Clause violation, the government risks creating a speech forum, which means losing its government speech defense and being forced to accept unwanted private speakers. And here's an example of one of those unwanted speakers following the 10th Circuit decision in Summum. Now, I want to point out here that what Justice Souter is describing is what I've called core government speech, where the government is allowed to express a particular point of view through private speakers. This thick version of government speech can be distinguished from the thin version, the speech selection cases, which are based on a particular discretionary function, Finley, Forbes, and the American Library Association. And there are greater, though still undefined, limits to viewpoint expression. For example, as Professor Fred Schauer has written early on, a public library could not decide to reject all books that criticize the American government or its wars. But that's exactly the kind of viewpoint discrimination the court wanted to permit in the monument context. The case clearly states that governments can accept and display an Iraq War Memorial, for example, while refusing a monument to Saddam, but also a monument depicting Iraqi civilian casualties. Let's see. Oh, yeah, so I got my little scribbled notes while Doug was talking. I said, Professor Laycock read to you from the same decisions I'm going to read to you from. He stressed the bad Alito, and I'm going to stress the positive parts of the case. So we'll see what you think. I think they're more central to the holding of this case. So to get that result, the court had to rely on the thick government speech doctrine from Johann and Rust, but it also had to extend those cases to cover broad thematic identity speech. So listen to the words he used to describe how the government's expressive intent with monuments. When deciding to display a donated monument, a government intends to instill a feeling or convey a thought. And so it selects only monuments which present the image of the city that it wishes to project to park visitors. And it would, and now can, reject any monument conveying a message with which it did not wish to be associated. So what this means for the Establishment Clause is that a government could get all the benefits of the government speech doctrine, the new one, the defense to free speech claims, without having to articulate a narrow or specific message. And one more point I want to go to is that the ACLJ's briefs, they represent the city in this case. They're the conservative Christian version of the ACLU, if you're unfamiliar with them. They really emphasize the government's role as curator or editor of these privately donated monuments. And they tried to push the court to rely on Finley, Forbes, and ALA. Why? Because if the government speech holding was the speech selection activity type, then the government would have discretion to pick and choose, yet the monuments would remain essentially private speech. And this, in turn, would provide more constitutional leeway, they thought, for private speech that expresses religious messages. And so this subtle doctrinal difference also plays into other current debates, like high school graduation speeches and legislative prayer. So this collision course is part of the reason, I think, for Justice Souter's melancholy warning. There's a quote, he said, "But government could well argue, as a development of the government speech doctrine, that when it expresses its own views, it is free of the Establishment Clause stricture against discriminating among religious sects or groups. Whether that view turns out to be sound is more than I can say at this point." Now, this lament from an articulate separationist was somewhat puzzling at first, more so because the Summum decision itself expressly noted that the Establishment Clause is a limit on the government speech defense. I don't think it actually did speak directly to this Ten Commandments issue, as was said earlier. So I think his words also address this larger, widespread concern. The Roberts Court is poised to write the final revisions to a changed Establishment Clause jurisprudence. And I think Professor Laycock is right that really part of it is how much is implicit and how much is actually explicit. And I guess I believe that saying some of these things out loud, yes, we do have the right to pick and choose among religions, and that's our defense to this case, is a lot worse than arguing over the meaning of the words in an Establishment Clause case. So let's give you this background. So for over 60 years, of course, the Supreme Court has proclaimed government neutrality, both between religions and between the religious and the secular. This tolerant approach adapts the framers' concerns to modern pluralism, which now, of course, includes increasing numbers of Muslims, non-theists, the non-church, the non-believers. But in recent decades, with the culture wars, there's been an increased support for non-preferentialism, this idea that government is allowed to promote religion generally and is restricted only from discriminating among religions. And also lurking in the background these less tolerant strains, including Justice Scalia's famous dissent in McCreary, where he celebrates the government's right to express monotheism, and then the far right's real proclamation that we are a Christian nation. So, and beyond that, in these particular kinds of cases, The two main tests that are there are the endorsement test and the tradition approach. And I think the endorsement inquiry, despite its flaws, is very important to keep in some form because it's viewer-centered and it's flexible enough to respond to changed social meaning. And its rationale, of course, supports a core purpose of this neutrality purpose, the Establishment Clause. It talks about the reasonable observer perceives a message of government endorsement of religion. The symbol can be invalid because it communicates to non-adherents that they're outsiders and to adherents that they're favored insiders. And if you focus only on history, it's inherently indifferent to how a religious display affects viewers and to shifting cultural norms, right? Instead, the judges focus only on the government's past practice, and frequently those opinions refer causally to our history and our religious traditions. Excuse me. So, before I explain my tradition on my theory on Salazar versus Buono and how it might provide a new model for synthesizing these two tests, I'm going to discuss why I have any idea that the Supreme Court might actually remain open to caring about what the viewer thinks, or a context-sensitive approach. So, Pleasant Grove versus Summum has been interpreted by some as the death knell of the endorsement test. And the conclusion derives from Justice Alito's long postmodern riff, which I would say is dicta, that you heard all of it from, read to you just a few minutes ago. But I think it's, they're calling that that's his dicta, that's his rambling, that's his setting up for the Buono decision, essentially. And I think that you can't say it's over based on the actual rationale of the Summum case. So if you look at, we already looked about how, if you look at how he keeps focusing on viewer attribution, and that, of course, is the essence of the endorsement test, he wrote, persons who observe donated monuments routinely and reasonably interpret them as conveying some message on the property owner's behalf. In this context, little chance observers will fail to appreciate the identity of the speaker anyway. But he also talks about by placing donated monuments in a park linked to the city's identity, it unmistakably signifies to all park visitors that the city intends the monument to speak on its behalf. So to rely on that for one purpose and exclude it for the other, I think was going to be hard to do. So looking next at what Buono indicates about the endorsement test's resiliency, it's hard to be certain of anything because given its complex procedural history, the justices were somewhat hemmed in by the earlier proceedings. I saw some indication of some movement potentially by Justice Kennedy, but an argument for it, but it's a very obscure argument. So instead, I'm just going to give some examples from Justice Alito's opinion. First, he observed that a symbol's social meaning varies by historical era. So when the cross was erected in 1934, and for some time thereafter, its social meaning as a symbol of World War I war dead would have been instantly recognized by viewers. Also at the time, it's this very isolated desert area. It's talked about as being a Mojave Desert Preserve. Well, that actually didn't happen until 1994, some 60 years after it had been put up. And I've done some reading on how these western lands are used, and they really are kind of open lands used by private parties for all sorts of purposes until the government claims them back. So that gives another context too. But he also talked about, very importantly, that it's completely different. A reasonable observer would not view the land exchange as the equivalent of the construction of a new or official World War I memorial in the National Mall. So the social meaning of preserving a 70-year-old war memorial is distinct from the triumphalism that would be conveyed, that is conveyed when governments sometimes erect religious symbols now in today's more diverse and combative times. It would be especially egregious, of course, to install a Christian cross in the nation's capital to represent all veterans. I think that the devil is always in the details, or bad metaphor. But the story of the Muslim veterans and how they felt thinking of this cross being memorializing them is very poignant, but so too is the story of these war-wounded World War I veterans off in the desert putting up this cross, which is a symbol to them at that time. And I'm not at all trying to defend the making of it as a national memorial. That's, if we have time at the end, I'll talk about that. That's government speech. That's ridiculous. But in this particular case, It's not the only World War I memorial. There's actually, I found out later after the case, there's a couple of dueling monuments now who are duking it out about who will be the country's official World War I memorial. So that kind of puts it in a different context as well. So now I want to show you what I mean by my claim. Okay, well, part of my thing is gone. That's okay. My claim that these two key Buono opinions, Kennedy's and Alito's, could be characterized as synthesizing the history-based and the current social meaning approaches into a sort of expanded endorsement test. So just as Kennedy said at one point that when a reasonable observer assessed the cross's message, the relevant factors should include considering that the land transfer was Congress's response to this Establishment Clause dilemma. It couldn't remove this long-term war memorial without conveying disrespect for those whom the cross was seen as honoring. Similarly, Justice Alito thought that the land transfer would satisfy the endorsement test, in part because a well-informed observer would appreciate that it was designed to eliminate any perception of religious sponsorship stemming from its location on federally owned land, while at the same time avoiding the disturbing symbolism associated with the destruction of a historic monument. So my thinking is this. If you look at this continuum, number one represents the original endorsement test where the reasonable viewer was thought to derive the meaning by looking at the visual surroundings, the immediate physical surroundings, kind of the casual passerby. And the second point along the continuum is what happened after Capitol Square versus Purnett, where it was clarified that the reasonable observer is actually charged with knowledge of the history and context of the symbol and the location, how it's been used. So Justice O'Connor used the term of the informed citizen. And this third position adds this additional factor that I'm saying was added for the first time in the Buono case. So while not fully articulated, the idea seems to be that if the reasonable observer was aware that the parcel was transferred to the VFW, and that the government's purpose was to avoid tearing down a cherished World War I memorial erected in 1934, then the reasonable observer would not perceive either the transfer or the newly privatized symbol as a government endorsement of Christianity. Perhaps we can call number three the open-minded or the political observer. Over there on the left is the reasonable adherent, the reasonable non-adherent, a great idea whose time has never come. And then off to the right would be the historical approach, which basically the judge who looks at a symbol without regard to the specific context, without regard to how things look in our time, and just says that this is part of our history. So avoiding that direction is the goal of my effort here to try to fold Buono in to the endorsement test tent. Got to talk even faster now. So my proposal post-summum was that if we are going to say that government speech defense can be used in support of religious/historical monuments, the only way that can be done without violating the Establishment Clause, in my opinion, would be to have disclaimer statements that are more than just disclaimers, that really explain the context, provide the narrative. The governments are using these secular reasons in litigation. They should be required to put this up as a condition of doing it. So I think that now it's a different question. I think it's a different question because it's an affirmative statement by government that, yes, you can post this monument because it's your identity speech, and you can pick and choose among what you're going to put up. It has a different level of magnitude than what happened in Van Orden. Also, in Van Orden, Justice Breyer's controlling concurrence relied in part on the donor plaque, surprisingly. It's a little-known fact about the Eagles, and he thought that because that's there, that viewers would attribute the message in part to their campaign and their work, and their secular social service work, which is no longer going to be relevant. So the disclaimer I proposed was fairly comprehensive. You should have seen my ordinances. They were crazy. So it was very, very long, but I think they should all have, technical difficulty, but surmounted pretty quickly. So they should all have this kind of part. The first part, the paragraph tells the story of the secular origins. They're relying on that. That should be part of what's shown to the viewers. The second part is explaining why it remains today on public property in neutral yet respectful terms. And the third, and it's all in my article if you'd like to read it, the third is the government's express statement of its neutrality and its respect for the citizens' diverse, belief systems. I guess that's why some people decide it's not worth it, right, when it goes wrong. So, and it's not unprecedented. These various types of signs have played small roles, kind of offstage roles, not discussed very much in some of the court's Establishment Clause cases. For example, in the holiday cases where the displays were held up, Lynch, I think, had a season's greetings sign, and the Allegheny outdoor part that was held up, the mayor had a sign, Salute to Liberty, whereas the Allegheny cross on the creche on the stairway had a sign that only said, donated by the Holy Name Society, and there was actually an inscription, Glory to God in the highest. So, and Capital Square versus Purnett also stressed the importance of a disclaimer sign. All 5 justices who wanted to keep the endorsement test were simply arguing over how large the disclaimer sign was, how clear it was. There, the donor was the KKK, so they didn't need to have a story. Anyone that would automatically signal to people that it wasn't the state of Ohio's idea. Some people, okay. Well, and I have some wonderful examples in an article I wrote about steps that disclaimer signs that cities have put up when they don't want to be associated with what has now become a politically incorrect statute, and they try to tell why it's still there. So it can be done. And it's optional in other cases, but the Establishment Clause imposes an affirmative obligation to correct any reasonable misimpressions of religious endorsement. So now that, especially now, post-Summum, when governments are going to benefit from the government-to-speech defense in cases of unspecified government identity speech, then the consequence should be that in cases of mixed religious, secular content, monuments, symbols, or speech, that the constitutional default requirement should be a disclaimer, which includes an explanation of the secular purpose and is required as a matter of course. I'm just about, I actually am out of time. You probably already figured that out, but I'm going to just try to wrap up as quickly as I can. The Mojave Cross case, it's too complicated to talk about this government speech or not, but there's parts in it that kind of show you the different levels of signs that could be up there. Alitos, who disagreed with the remand, presumably wants this plaque put back up, which talks about, it's all that would say would be it was erected in 1934 by those veterans for this purpose. Kennedy went a little bit further and said, if the land transfer is not enough, then maybe a sign showing the change in land ownership should be looked at. The government actually plans to put up, according to the Solicitor General, a sign on Seaman Road where people driving by and seeing the cross will go by, explaining something, but not exactly sure what. And I guess my approach is not quite as conciliatory as I imagined, because at the oral argument, Chief Justice Roberts railed against the use of what he called special warning signs for only religious property. But I would go a little bit further and do a similar type of sign for this kind of case. We'd have to explain the original origins and set it in its historical context, have to explain why it's there now because the land has been transferred, and have to include a specific disclaimer of the religious message and a specific statement of the government neutrality and respect for veterans of all different religions. I think you all know that disclaimers are not a panacea. Sometimes they're too small, sometimes they're simply not credible. And we can answer any questions on the National Memorial Designation during question times. But I think that this kind of case-by-case and kind of simple practical solution is not all that appealing, and it's not very satisfying for anyone on either side of these stories. But I think separationism is unlikely to return anytime soon, and an intolerant historicism really threatens. And so these kinds of makeshift remedies are really what we have left, I think, to solve some of these problems as they are going to keep coming back. Even post-Summum, there's a Green versus Haskell case where they put up a new Ten Commandments case, so I think that this is one solution, so we don't end up with this. Thank you.